Good evening, everyone. I call the Senate Civil Law and Data Practices Policy Committee back to order. Part 2 of our hearing today on March 15th, 2022. So we have Senate File 724 from Senator Lang. Senator Lang, welcome to the committee.
Well, good afternoon, Mr. Chair and members. Thank you again for inviting us to, I think this is actually the first time I've been in front of the committee. Before you this evening, I have Senate File 724. 724 is something that myself, the department, and the Veterans Affairs Committee has kind of had on the discussion table for a couple of years now, actually. And it has everything to do with the Universal Code of Military Justice and how it applies to the state of Minnesota. This is an agency bill that, in all honesty, Mr. Chair, I don't have the best knowledge of. It's an in-depth bill that has a lot to do with lawyerese and in legal speak, which is why I have with us today Lieutenant Colonel Blomgren, who is online, and I appreciate him being able to join us online. We had him here last week, and of course we had a little long-running schedule. And along with that, I have Mr. John Kerr with us today. So that, Mr. Chair, if you want to, the good thing is it's got a zero fiscal note. So. But if you want some details on the bill, I'm going to have to just say that it has everything to do with the UCMJ and how it applies to the state of Minnesota.
Thank you, Senator
yes,
Lang.
That is correct.
There is an amendment in our packets. Do you want to deal with that first and then go to explain the bill? Senator Bigham.
Mr. Chair, I'll move the A2 amendment.
Senator Bigham moves the A2 amendment. It deletes a couple of sections. Maybe Ms. Primo, do you want to highlight what it's deleting from the bill?
Mr. Chair and members, it deletes section 1 and 2 on page 1 that have to do with some data practices provisions.
All right, Senator Lang.
So, Mr. Chair, the A2 amendment, and Mr. Kerr could probably go a little more in depth on this one, but it had everything to do with the Newspaper Association being cautiously cautious of the privacy data and effects. So, in an effort to make this bill a little more streamlined and get it to the floor and get it passed as you know, in the shape that it is, we removed each one of these sections and made references to the federal code that we will be abiding by. So. That is the A2 amendment in a nutshell.
Any discussion on the A2 amendment? Senator Latz. I believe you're still muted.
Yeah, I can find the raise hand button. Mr. Chairman, I'm just wondering what the impact is of not doing the two data classification provisions here. I understand there may have been some concern, but there must have been a reason these provisions were in the bill. So I think I'd like to know what was intended by those provisions before I decide whether I'm comfortable deleting them.
Senator Lang, do you want to take that?
Mr. Chair, I think I'd probably turn that question over to either Lieutenant Colonel Blomgren online or Mr. Kerr, maybe if he has an answer.
You want to?
They dealt more directly with the...
Mr. Kerr, welcome to the committee. If you'd identify yourself on the record and then help answer our question.
Thank you, Mr. Chair, members of the committee. My name is Don Kerr. I'm the Executive Director of the Minnesota Department of Military Affairs. And we had the two provisions in the bill in an attempt to really more closely align the way that the Data Practices Act interacts with the agency along the same lines that the Freedom of Information Act does for federal data. There's some guidance that we've received from the federal side that we kind of have to comply with because of the supremacy clause of the Constitution. And this would have brought state law kind of in alignment with what we believe the federal law that aligns with that is, at least with the second article. And the first article really has to do with military forces called the state service. So we have some concerns about not passing Article 1. And again, that's when our service members are called to state active duty, for example, when like they were for the riots and the civil disturbance last spring, think it was last spring.
Both springs.
The state rule would apply under those circumstances, except where it may be modified by direction from the Department of Defense. And that's where this gets really weird. Our service members are both federal and state, and determining what status they were in gets kind of complicated as we're going through, particularly data requests, because they're so different on the federal and the state side.
Thank you. Lieutenant Colonel Blomgren, do you have anything to add to that question?
Thank you, Mr. Chair, committee members. Yeah, I would just add to that. I concur with Mr. Kerr's assessment of that. In relation to Section 1, really it's just aligning with DOD policies. So currently there's a DOD policy that states anybody that is in a certain rank, that's typically below general officer, their names will be redacted in any FOIA request. The purpose behind that being there have been, terrorist organizations that have released names and homes and records of service members that have deployed overseas. And so the DOD has launched a policy that in any FOIA request, names will be redacted. So this is essentially aligning with that in state law to consider military personnel data private. I will say that we have taken that position regardless of what is in the statute. This is simply to clarify it. But we will continue to align with the FOIA provisions and policy of the DOD. Simply to
I believe Senator Bigham has a question on this point.
Yep. Thank you, Mr. Chair. So, Mr. Kerr, if I understand correctly, if the federal government asked for the guard, they would be protected. But if the state called them up, like what happened with the civil unrest, this wouldn't cover them?
Mr. Kerr.
Mr. Chair, Senator Bigham, we believe that the federal law is going to cover them either way.
Okay.
What this would have done is clarify Minnesota law to remove conflict. And so the potential would be there now if we did what we have to do based on the supremacy clause and follow federal law, then that would put someone in a position to file a lawsuit against the agency for not complying with state law. And then we'd have to defend that in court and it would be adjudicated.
And Mr. Chair,
Senator Bigham.
Senator Lang, what was the newspaper's objection about conformity?
Senator Lang.
Well, Senator Bingham, Mr. Chair, this is actually going to be a question for Mr. Kerr, too.
Oh.
That was just,
I'll go to Mr. Kerr, and then Mr. Newmeister is raising his hand behind you on this question. I'll go to him, too, in a minute. Mr. Kerr.
Mr. Chair, Senator Bigham, their concern was about investigative ability in the event of malfeasance by a service member while they're in support of the state. They wanted to make sure that they were not blocked from understanding the same type of data that they would have in the event that a law enforcement officer performed an act or alleged act that would provide them access to do the necessary reporting.
Thank you. Mr. Newmeister, do you want to come up and contribute to that answer as well?
Mr. Chairman, members of the committee, my name is Rich Newmeister. Several years ago, there was an investigation by KSTP and other media outlets about sexual harassment and possible sexual abuse by National Guard folks. One of the ways the media was able to do is get that information. Then all of a sudden this appeared. And whether it be by coincidence or not, I have no idea, but when I saw that and the total exemption from the Data Practices Act, which it was proposing, raises a number of flags. It was when Koji was involved, I myself as an individual, and the Newspapers Association. And Mr. Kerr can reflect about some of the discussion that went on behind that. Mr. Chairman, members of the committee, I had a discussion with Mr. Kerr almost a year ago when this bill was up. So there was an understanding that it would be amended to take this out. The bottom line is the department, what it's going to have to do is, again, has to do that comparison when a data request comes in. And if it's under federal law covers. If it doesn't, than the state law, like any other agency does. That's covered simultaneously sometimes by the federal law and the state law. To achieve accountability and transparency, it's important that the broad sections that's being proposed here, which is basically, from my perspective, exemption from the Data Practices Act, raises a number of issues.
Thank you, Mr. Newmeister. Follow-up?
No,
Okay.
thank you, Mr. Chair.
Senator Latz, did you have any follow-up on your end?
Mr. Chairman, this has been quite helpful to understand this. And it sounds like there's going to be a conflict of laws, no matter the purpose of the investigation, no matter the purpose of calling up the guard into action, because they're kind of a hybrid entity in that regard. So I guess I'm fine with going ahead and proceeding with the amendment to delete those provisions. At some point, it may end up being litigated if the guard decides they're covered by federal law in a particular data request and they don't release anything. But maybe that's the way it would have to play out. So, all right, I've got nothing further. Thank you.
All right, thank you, Senator Latz. Any more discussion on the A2 amendment? Seeing none, all those in favor of adopting the A2 amendment, say aye. Aye. Opposed, no.
Aye.
The motion prevails and the amendment is adopted. So we're back on the bill as amended. And Senator Lang, do you want should we turn to your testifiers for going through the bill now at this point?
I believe Lieutenant Colonel Blomgren would probably dive into the bill, sir.
Lieutenant Colonel Blomgren, welcome to the committee. If you would identify yourself on the record, and then if you're able to try to speak loudly on your end. We were having some audio issues on our end in the big room that we're in, so if you're able to speak up, that would likely be helpful. So welcome to the committee.
Thank you, Mr. Chairman, committee members. I hope you can hear me okay. Let me know. I can always call in on my phone as well. That would be easier. For the record, I am Lieutenant Colonel David Blomgren. I serve as General Counsel for the Minnesota National Guard and Department of Military Affairs, where I serve as the full-time legal advisor to the Adjutant General and other senior leaders in the organization. I assumed this role in 2018 after spending 11 years on active duty in the Air Force. First, let me thank you for inviting me to testify this afternoon in support of this bill. Compared to the active duty force, our military justice structure is quite different, given the fact that most of our members are not on a duty status most days of the month. While we currently have the legal ability on paper to conduct a court-martial, there are gaps that would make it legally impractical to conduct one now. This bill will fill those gaps and in turn will provide that additional legal tool in the commander's toolbox to ensure good order and discipline in the Minnesota National Guard. I'll briefly go over a quick overview of what gaps this bill would fill. The first one is the legal authority to receive law enforcement data of Minnesota National Guard members when they are investigated by local law enforcement. In many cases, when local law enforcement investigates a crime and their prosecutor determines there is not enough evidence to pursue criminal charges, we still have the ability to pursue administrative action or courts-martial. 9 times out of 10, the local jurisdiction provides us the relevant investigation so that we can take it action. Or some jurisdictions currently do not, and that simply adds to the time it takes to investigate wrongdoings, since we must then do our own investigation. This is particularly when it comes to sexual assaults. This bill would authorize the Adjutant General to receive, via request from my office, law law enforcement data of members in our organization for the sole purpose of taking administrative or criminal action. This bill also fills a number of jurisdictional gaps or ambiguities that currently exist on paper. Specifically, it clarifies when members are subject to the Minnesota Code of Military Justice. It clarifies which crimes are considered military-specific crimes and therefore gives the National Guard primary jurisdiction over, and clarifies the maximum punishment for the punitive articles of the code. Another gap that we've experienced in the National Guard is the inability of out-of-state attorneys to provide military legal advice without having to go through the pro hoc vice process. This bill would allow for out-of-state licensed attorneys to provide military defense services or serve as military judges, provided they are otherwise qualified for such duty by the Judge Advocate General of their service and are a member of another state's bar. This is consistent with how the JAG Corps operates on the federal level. While we typically are able to utilize Minnesota licensed attorneys to provide these services, there are times when we need to go out of the state, particularly when senior members are under investigation for misconduct. This change has been socialized with the Minnesota Office of Lawyer Registration and the Office of Professional Responsibility, and they concur with the change. The fourth gap this bill fills is the appellate process for a court-martial. Currently, it's unclear how a defendant or the government would appeal a court-martial. This change clarifies when the appeal period starts to run and clarifies the appropriate appellate authority as the Minnesota Supreme Court. These changes have been reviewed and concurred by the Minnesota Attorney General's appellate division. And finally, this bill aligns the Minnesota Code of Military Justice with the updates to the federal Uniform Code of Military Justice with respect to newly added punitive articles. Again, I thank you for your opportunity to testify today, and I'm happy to answer any questions that you may have.
Thank you, Lieutenant Colonel. Senator Lang, anything more from you, or Mr. Kerr, anything more from you?
I guess we'd be open to any questions from the members, Mr. Chair. I guess from my standpoint, as far as closing statements go, this is a fairly complicated bill when it comes to law. From my point of view as a service member, I can tell you that there are very, very many circumstances in the past when, the National Guard of Minnesota has been limited what we can and can't do as far as conducting ourselves in conducting a court-martial or conducting an inquiry of any kind. So this would hopefully streamline that process between the Guard and the federal government. So, with that, Mr. Chair, I stand for questions.
Thank you, Senator Lang. So, members, any questions from the committee? Senator Limmer.
Thank you, Mr. Chairman. Senator Lang, maybe one of your testifiers could answer a question for me. On page 5, lines 10 through 13, there's a reference to a limitation of violations. It's in a paragraph entitled 3-year limitation, and then it explains in the new language the limitation for violations of any offense prescribed shall be the lesser of the limitation prescribed by, and then they have different codes of military justice, state law, manual for court martial. So can one of your guests explain what that really means?
Lieutenant Colonel Blomgren, I believe, is the
All right.
lawyer that would probably be able to answer that question.
Lieutenant Colonel Blomgren.
Yes, Mr. Chair, Senator Limmer, great question. Essentially, what this means is, if we have a crime that we want to charge in court-martial, there's a number of ways that we can charge that number. So if it's a punitive article in the Minnesota Code of Military Justice, we can utilize whatever statute that is. There's a general article already in existence where we can assimilate the Uniform Code of Military Justice. So let's say it's, for whatever reason, it's not on our books. The UCMJ on the federal level updates its laws. We can then utilize our general article to assimilate that crime and charge whatever the federal law has changed. Or in theory, we could use the existing Minnesota criminal code found in 609. So essentially what this does, it says, however we charge, we're going to charge this member, the sentence is going to be essentially the lesser of all of them. So it's giving the benefit of the doubt to the accused. If there are differing, there are differing limitations as far as statute of limitations or a sentence, it's going to be the lesser of those three options. So the benefit goes to the accused.
Senator Limmer.
Thank you. Lieutenant Colonel, is the 3-year limitation, is that considered, for lack of a better term, a statute of limitations? And and if it does mean that, does it mean that it could be in conflict with other areas of law, such as state law?
Lieutenant Colonel.
Yeah, Mr. Chair, Senator Limmer, yes, sir. That's essentially referencing the statute of limitations. And I think essentially we are, if the state statute has a lesser statute of limitations than the federal jurisdiction, then we're going to follow the state law. So I think we did that intentionally, giving the benefit to the accused for that very reason that you mentioned that there is a conflict in the statute of limitations. There are some, the Uniform Code of Military Justice on the federal level, there are some crimes that have no statute of limitations. If the Minnesota Code did have a statute of limitations, we follow the Minnesota Code to your point, to avoid that conflict in an appeal.
Thank you.
Thank you, Senator Limmer. Any other questions from members? Senator Anderson.
Thank you, Mr. Chair. On page 2, on the bottom, it talks about practice of military law, and it says, any commissioned officer of the United States, state, or military force who meets the following qualifications, and at the end it says is exempt from section 481.02. Could someone explain that section?
Lieutenant Colonel.
Mr. Chair, Senator, thank you. Yes, that is the unauthorized practice of law section. So currently, if we do have somebody from out of state that wants to do a court-martial, they have to go through the pro hoc vice process to be temporarily allowed to practice law in the state of Minnesota. So we have socialized the issue with the lawyer registration folks and the bar to determine whether or not that would be an issue for them, and they agree that rather than going through the pro hoc vice every time, if we would solidify this in statute to allow those members to be able to practice law in the state without going through that process, that would be the most efficient way. So that essentially what this is doing is saying that those members that are attorneys that are licensed out of state but are otherwise authorized to do military law, they will not be in violation of the unauthorized practice of law section.
Mr.
Senator
Chair.
Anderson.
Does this apply, because it says only any commissioned officer, does this apply also to non-commissioned officers?
Lieutenant Colonel.
Mr. Chair, Senator Anderson, yes, that's correct. It's only commissioned officers that are judge advocates in both the Army and the Air Force. And so we have no non-commissioned attorneys that are judge advocates.
Thank you.
Thank you, Senator Anderson. Anyone else on the committee? Check online. Seeing no further hands on this,
Mr. Chairman, I have one last question.
Senator Limmer.
Thank you. Senator Lang, can I direct you to page 11 and line 12? It's a question of, under the section of prohibited activities, with a military recruit or trainee, and it talks about consent of, it looks like consensual consent, but it's not to be used as a defense if there was a charge. Is that different than a civil court?
Lieutenant Colonel, would you like to take that?
Yeah, Mr. Chair, Senator Limber. Yes, sir, that's a great question. So this is essentially saying that if you are a recruiter and you have consensual sex with a recruit, we would consider that to be a violation of the statute. So that would be a criminal offense. You're in a position of trust, and regardless of whether or not the recruit consented to the sexual activity, the accused would not be able to use that consent as a defense to that crime.
And
So, Lieutenant
Senator
Colonel,
Limmer.
in that regard, consent would be a defense in a charge in a civil court, correct? So the military is a little stricter in this.
Lieutenant Colonel.
Yes, sir, Mr. Chair, Senator Limmer, that is correct. Yes, it's stricter, it would not be a defense on the criminal proceeding, or it could be on the civil side.
All right.
And Senator Lang.
Thank you, Mr. Chair. I think I might be able to bridge the gap a little bit on this one. The recruiter-recruit relationship that exists while the recruit is going through the process is something that is specific to the military and the military only. That is something that I think we'd be pretty protective of, to keep this part of the consent in law. Whether or not that recruit is consensual or not, the relationship would be unauthorized, from my viewpoint.
Yeah.
And I believe.
All right.
And Senator Limmer, I'm also reminded by staff that's also a section under judiciary's purview, and you're getting the bill next if we pass it out from here.
As it should be, Mr. Chair.
Senator Latz.
Thank you, Mr. Chairman. I'll just note that that same consent provision applies to the subdivision 2 offense in this code as well, the use of training leadership positions. So it's not just a recruit, but it's in training situations as well. I don't recall off the top of my head if there's something comparable in some of our statutes relating to, say, a teacher and say, an 18-year-old senior in high school, or clergy, and someone under pastoral care, or a therapist, and someone who's there. I don't recall specifically if we have a statute that says consent is not a defense. If we don't have such a statute, we probably should. But if you're in state court facing a state criminal charge over these kind of things, I think those would be analogous situations.
Mr. Chairman.
Thank you, Senator Latz. Senator Limmer.
Mr. Chair, Senator Latz, I vaguely remember we recognized the authority factor in some of the examples that you mentioned just now, and I do believe we do have statutes recognizing when someone is in an authority figure that puts an undue effect on the victim, and despite the fact that there's an undue effect, it could lead to a consent, but because of that authority factor involved in that relationship. I think we covered it in statute, but we can ask our research people when it comes to the Judiciary Committee. Thank you for bringing that up.
Thank you, Senator Limmer. Anyone else? Senator Anderson.
If I'm understanding what Lieutenant Colonel Blumgren said on page 2, that a non-commissioned officer is included in that, was I understanding that right, or is it only commissioned?
I believe it was only commission, but Lieutenant Colonel, maybe you could clarify your answer if I'm remembering right.
Sorry about that. Yes, Mr. Chairman, Senator Anderson, it is only commissioned officers, and the reason behind that being only commissioned officers are judge advocates. And the term judge advocates that's our JAG Corps. So the attorneys in the military system are only commissioned officers. And so this really only applies to attorneys that would be from out of state. So that's the rationale for only having commissioned in there, be applicable to non-commissioned officers. Simply because we don't have any attorneys in the military system that are non-commissioned officers. And Mr. Chair, to the other question that was raised regarding state statute in the criminal code, there is a statute that is a criminal sex offense. If a member or an individual is in a position of authority or trust and is 48 months or older than the victim, then they can be charged for a similar type of crime as we're trying to do here. So there's that 48-month gap that wouldn't apply in this case. Which I think is reasonable for the military. Sometimes we have older members that are trying to enter into the system where they could be very older than.
All right, thank you. Thank you. Any other questions? Seeing none, Senator Latz, do you have any final comments to make on the bill? I'm sorry, Senator Lang.
Don't give me the opportunity.
I was going to say, there's only been a few times, Mr. Chair, that our names have been confused on bills a few times. I don't,
Senator
other
Lang.
than saying I appreciate the opportunity to get the bill in front of you. I think the department appreciates the opportunity to move down this streamlining of processes between the federal and the state government, and I can tell you that the Minnesota National Guard truly appreciates the opportunity to really self-govern themselves. So with that, Mr. Chair, thank you.
All right. Thank you, members. Seeing then, if someone will make a motion for Senate File 724 as amended. Senator Bigum.
Mr. Chair, I'll move that Senate File 724 as amended be passed, recommended to pass, and sent to judiciary.
On that motion, all those in favor say aye.
Aye.
Aye. Opposed say no. Motion prevails and the bill is passed. Thank you, Senator Lang.
Thank you,
And with
members.
that, members, this committee now stands adjourned.
Thank you, Mr. Chair, members.